afternoon and welcome to the Presumption of Rationality, Psychological Challenges to Legal Certainty. I'm Francis Levy. Ed Nersessian and I are co-directors of the Philoctetes Center. I just wanted to call your attention to the art on the walls. It's from a show called The Body as Image, which accompanied our 6 roundtables on sexuality, beginning with mating and captivity early in the fall and ending last week with paraphilias. And it's really, as I said last night, bodies and images is the best way to describe it. There's a painting, there's a drawing by Philip Pearlstein. There's a quilt by Katie Commodore inside, which is composed of patterns of sadomasochistic imagery, but you can see it's diverse, it's perverse, and it's by a group of artists from varying stages of life and age ranges and so forth. Now, Nicholson Baker, Edward Albee, John Turturro, Judith Thurman, and Simon Winchester are all among the distinguished panelists who will be coming to Philoctetes this fall and into the winter. So go to philoctetes.org to see our calendar. Also, go to philoctetes.org and past programming to see any Philoctetes roundtables. It's all recorded. As you can see, we have a 3-camera setup, and it's simulcast. So if you're at home, you can always tune in if you know the time of the roundtable. Please remember to silence all cell phones. Books will be on sale after the roundtable. I am now pleased to present Ann Dailey. Ann Dailey is the Evangeline Starr Professor of Law and Associate Dean for Research and Faculty Development at the University of Connecticut School of Law. Professor Dailey received her BA from Yale University and her JD from Harvard Law School. Her current research focuses on the application of psychoanalytical developmental psychology to modern conceptions of children's rights. She is the recipient of the 2003 Korst Prize from the American Psychoanalytic Association and recent guest editor for the fall 2007 issue of American Imago entitled Legal Analysis. Dr. Dailey will moderate this afternoon's program and introduce our other distinguished guests.
Would you like me to come up to introduce or sit?
It's fine to do it there if you're happy.
So welcome, everyone. It's really an honor to be moderating this panel. I'll first introduce the guests, and then we'll open it up to discussion. I'm going to introduce them alphabetically. So I'll begin with Professor Peter Brooks. Peter is currently the Mellon Visiting Professor at Princeton University after being on the faculties of the University of Virginia, and before that at Yale, where he was Sterling Professor of Comparative Literature. He's a 2007 recipient of a Mellon Foundation Distinguished Achievement Award, which cited him as, quote, one of the leading literary critics of his generation. Peter is the author of several books, including Troubling Confessions and The Melodramatic Imagination. It is hardly an understatement to say that in addition to his other accomplishments, Peter has been an inspiration and a mentor to an entire generation of young scholars doing work in law and the humanities. Carol Gilligan is our next panelist. She's a psychologist and novelist, as well as university professor at NYU. It would be hard to overstate the influence of Carol's work in both the academy and the popular imagination. In addition to her revolutionary work on children's development, she is the author most recently of 2 books, The Birth of Pleasure, published in 2002, and Kira, a novel, published in 2008. And she has a book about to be published by Cambridge University Press with David Richards entitled The Deepening Darkness, Patriarchy, Resistance, and Democracy's Future. Nomi Stolzenberg, to my left, is the Nathan and Lily Chappell Professor of Law at the University of Southern California Law School, where she specializes in law and religion, among many other things. She is a founding director of the USC Center for Law, History, and Culture, which is dedicated to multidisciplinary research and teaching. Her path-breaking work on liberalism focuses on the relationship between liberalism and religion, and in particular on liberalism's romantic conception of the psyche in areas such as religion, war, and love. And our final panelist, Kenji Yoshino, Kenji is the Chief Justice Earl Warren Professor of Constitutional Law at NYU Law School. And like Peter, Kenji was also formerly on the Yale faculty, where he taught at the law school for a decade before moving on to NYU. He's the author of the book Covering the Hidden Assault on Our Civil Rights, a masterful combination of memoir and civil rights scholarship that has been the subject of numerous awards. And his current work is entitled Imagining Utopias, about the use of imagination in law. So it's really an honor to be here at this roundtable today with these distinguished participants. So we'll begin. And I know we're not supposed to have any notes, so I really just have a couple of things that I want to say by way of introduction, which I know everyone says, and they talk for half I promise I really am only going to talk for 3 minutes. There were a couple of themes I think I wanted to bring out in my thinking about law and imagination, which in my own work, which is how this panel came to be. It's clear that imagination does play a role in the creation and the operation of the legal system and in the life of the legal actor. And there are many ways to approach this topic. Our panelists today are each going to come at it with their own views of the matter. But I wanted to mention just two. The first is the role of imagination in the conception of the individual and human nature. And law operates, we would say, in the dominant discourse with a legal fiction of the rational actor, or sometimes this person is referred to as the reasonable person. So one of the questions we might address today is what happens to law and to this legal fiction when we begin to push beyond it to address the ways the non-rational, let's say, imaginative forces which operate in human nature. So that conception of the individual is the first theme that I thought might come out today. The second, though, I also am interested in taking a step back and looking at the question of the legitimacy of law itself. What happens when we start to take account of imagination? What happens to what we call in the legal sphere the rule of law? In general, under the rule of law, we think the legitimacy of law derives from reason. The rule of law embodies, in fact, what we would say as the triumph of reason over passion, or the irrational. So what happens when we start to think of law as produced not by reason, but by imagination? That law might be the creation of our own imaginings. So law might be thought of in that way as storytelling, or narrative, or really even just simple fantasy about how we might wish the world to be. So in that view, the rule of law as it operates now is about the repression of the imagination. And Robert Cover has written about this as well when he wrote about how law is the narratives that the trajectories plotted upon material reality by our imaginations. So if we think about laws produced by imagination, it raises some troubling questions, I think. In particular, the question of what is lawlessness in a world where law is produced by imagination? And the first thing that comes to my mind is Guantanamo Bay, in fact. From a rule of law perspective, we would say Guantanamo Bay is a lawless place where power and coercion are operating rather than reason. But there's clearly not an absence of imagination at Guantanamo Bay. It's really not, from an imagination perspective, it's not so different a place than the world in which we live. It's just that the imaginings of Guantanamo Bay are darker, more sadistic, immoral even, right? Without the rule of law fiction, the fiction of reason as the legitimizing force of law, the question is, do we lose our critical vantage point for critiquing lawlessness, for critiquing the exercise of power and coercion like we see at Guantanamo Bay? Do we still have a position in which to critique bad imaginings? So I guess I'm just going to end now with the question of whether the fiction of the rule of law, the legal fiction, like perhaps the fiction of the reasonable person, are a protection against forms of tyranny. So does the full embrace of imagination, where we really struggle deeply with the imaginative, non-reasoning parts of human nature, does it lead us perhaps in the direction of more authoritarian, maybe less democratic and liberal forms of law? So those are my two sort of big themes, the conception of the individual and the legitimizing basis for law. I'd like to open it up to the panelists now. I don't know if, I'm sure you all are coming at the question of imagination in law from your own perspectives, but there may be something there that coincides with your thinking about imagination law. And Kenji, I don't know if you want to start or throw in your 2 cents about maybe how you came to be interested in coming to today's panel.
Absolutely. So first of all, thank you for having me here, and thank you to Anne for moderating this. I think I'll just make a few, give a few responses to that. I think the first one is to say that the distinction between the imagination and reason is, with respect to statecraft, is as old as Plato's Republic. And so we have in Plato the idea that reason should be the ground of the law because reason is common. You know, everyone can participate in the dream of reason, at least as cast by Plato. So even the slave boy and the Meno can be taught the geometric proof from scratch, and the knowledge is actually within him and just needs to be drawn out through dialectic, right? Whereas the dangerous figure is the poet, right? The poet who is imaginative, who is ecstatic, who is metonymic rather than rational, who can't even explain himself or herself why he or she is saying what he or she is saying, much less convey that to another person in a way that could be reproduced, right? One of the things that we should remember about Plato, of course, is that when Plato banishes a poet from the city, he's actually banishing the dominant discourse. You know, it's a philosopher at that time who's the upstart, and it's a poet who is the traditional purveyor of wisdom in that society, as Iris Murdoch reminds us in her nice monograph. So I do think that this is a really deeply rooted and storied distinction between law on the one hand and, rationality on the one hand and irrationality or imagination on the other, and that we want our law to be based on the former rather than the latter in most conventional accounts of the rule of law. So to that point, you know, I think we've just set out the conventional default wisdom in society. But where I think it gets interesting is to think about what you were saying, which is to say so often what we're dealing with when we're dealing about rationality is a kind of fiction, so that the rational person or the reasonable person in law is itself an imaginative construct. That person doesn't exist anywhere in the world. And oftentimes we have to exercise our imagination in order to go to the rational place. In order to fully understand, say, a rational projection into the future, you have to imagine things that have not yet occurred, right? So how do we balance the idea that, you know, rationality is what we aspire to base our law on because there's something so dangerous and lawless and perhaps even fascistic about the imagination, because the imagination can devolve into the because I say so, you know, and it's non-participatory. How do we balance that impulse with the other impulse that says, well, it's too stark a distinction between rationality and imagination because rationality always contains some seeds of imagination. So just one additional thought, and then I'll throw it open to others. I mean, my own work, you asked why I came to this panel, is mostly centered on civil rights law. And the piece that I'm working on now, Imagining Utopias, is the idea that sometimes we think of the law, or generally we think of the law as not allowing for imagination. But if we actually look at why that is, the impulse is not against imagination per se. It's against allowing things that are not allied with the proper use of force, right, to infiltrate the law. So what we're really dealing with is not an antinomy between imagination and rationality, but an antinomy between imagination and coercion, right? Mm-hmm. So that the more coercive discourse is going to be, the less we're going to want people to engage in flights of fancy. So there's going to be an inverse relation between force and fancy. And what's tricky about that is that if we believe that imagination still always surfaces within the law, how do we allow that to have its voice? And what I'm toying with in this piece is to say sometimes the law quite self-consciously denudes itself of force precisely in order to allow fancy its free reign. So I'm thinking here of dissents in the Anglo-American tradition. I'm thinking of concurrences. I'm thinking of dicta, hortatory law, Senate resolutions, human rights law, you know, a wide panoply of law-like pronouncements that don't have any force, which I think we keep around precisely because they allow us to imagine better societies. And Cardozo, as Peter taught me when I was a student, once said that dissents are much more literary than majority opinions precisely because the justice can speak for the ages and really speak in his own voice and doesn't need to worry about getting votes or selling it to the rest of the country. So that was a pretty long peroration there, but I will stop there.
Let me, rather than making a statement, pick up on your comment on Guantanamo Bay, because it's something that disturbs me and disturbs probably all of us. And I think it raises a larger question that extends beyond the mess of Guantanamo Bay to the whole criminal justice system and criminal procedure. And that's that the rule of law and its rationality doesn't really know what it wants a criminal to be or a criminal suspect to be. The language of the law, which we have largely inherited, at least through the American Constitution, from the Enlightenment, uses phrases like the free and rational will. Confessions are supposed to be the product of a free or rational will. The suspect's will is not supposed to be overborne. In a criminal case, you always have to prove mens rea, right? A dirty mind, not a dirty mind, but a guilty mind. Compare that with our understanding, our post-Freudian understanding of human beings, where you could say all mens is rea in some sense, right? We all have layers and layers of guilt that can be triggered in interrogation or in situations in which the law puts its actor. We don't know, and it's one reason the courts have had such trouble dealing with things like confession. We don't know what we want to do with people when they have become criminal suspects. And when we have put them away, as in Gitmo, people don't even want to think about them. You know, I mean, I know there's a dedicated band of human rights lawyers who have been working on these cases, but I think for the majority of the American public, and the fact that it hasn't come up in the electoral campaign, presidential campaign, I think proves it. They don't want to think about this, right? These are forgotten people. So is it really that the law is acting rationally, or is the law kind of Dostoevskian, that it seeks abasement? I just end with thinking of the brothers Karamazov and the fact that Ivan Karamazov, when he enters court during his brother's trial and gives a true confession, he is not believed. The court says to him, "Your words are unimaginable and impossible in this place," whereas they accept Dmitri's false confession. So I'll stop there for the moment.
I don't know if there.
Yeah, I mean, I think that's an interesting point to jump off of. In a way, I agree. I mean, I think thinking about the criminal justice system and looking in horror, as we all do, at the domains, whether it's the seemingly far away, exceptional domain of Guantanamo or the anything but exceptional domain of ordinary criminal law, those look like spaces that are the very antithesis of the rule of law. I'm not sure I agree with the question, with the premise that we don't know what we want the rule of law to be. I actually think that there's centuries of discourse confronting precisely the question of what is to be done with a criminal suspect. That's very, very, very mindful. I mean, to go to the title we ended up with the inherent uncertainty of guilt, of proofs of guilt, with the fallibility of any human system of criminal justice, and that it was precisely in the context of that awareness. And you can, if you look at sort of medieval canon law discourse, or you can see analogs in rabbinic discourse, it's very explicit that it was actually in that context that I think our ideal of the rule of law that's with us today was forged. And I think it came up with an answer. But the problem is that the answer was perhaps impossible to operationalize. But I think if we look at the answer, one of the things it shows us is that there's two radically different conceptions of rationality. So one conception of rationality that I think was forged and explicitly articulated in the context of both theological and legal contemplations of this problem. How do you prove, how do we know if someone is guilty as a crime? One was an entirely fallibilist conception of reason. Kenji, going back, you're sort of referring even further back to antiquity, a totally Aristotelian conception of reason, where the starting premise is we can never know for sure. The problem of the criminal justice system is not only the problem of the bad guys, that there are people who do terrible things and we've got to lock them up or incarcerate them or punish them or deter them, but that there's an equally difficult problem, the problem of the good guys, the law enforcers, and the problem there is because of the inherent uncertainty of the inherently fallible instruments of human cognition and proof, we're liable to get it wrong. And if we get it wrong, right, there's an incredible mindfulness of the risk of error and what was at stake in that risk. And in response to that risk, we can, first of all, long ago, right, at least as far back as the medieval period, further back, I mean, you can look at the Bible and you look at biblical criminal law, and while the substantive criminal law of the Bible, as it were, seems terribly harsh, and we're going to stone people for adultery and cut off the hand of the thief, but the procedural law was incredibly liberal. It was what we think of as the rule of law. It was all about due process rights and all about the things, Peter, that you're talking about in the name of the inherent fallibility of human reason. The problem, though, is that, in fact, if we adhere to the rule of law, which is to say to this procedural regime of due process rights, which is entirely oriented around minimizing the risk of getting it wrong and essentially judicial murder at the extreme, no one can ever be found guilty of anything. And so what we see time and again in one historical era after another is the invocation of a logic which has become very familiar to us now, which is the logic of the emergency. It's the logic of the state of exception. It's the logic that says, oh my God, look, people are doing terrible things and our criminal justice system isn't working. So we've got to relax the rule of law. We've got to relax due process standards. Yes, human reason is infallible, but we can't let that stop us from actually reaching judgments, reaching guilty verdicts, however fallible those judgments are. And so you sort of see the double-sided edge of this fallibilist conception of reason that can either be that can either yield an impossibly high standard of rule of law and due process, but can just as well be sort of turned on its head and be used to justify the prosecution and conviction of people without observing due process rights and without an adequate evidentiary basis in response to the specter of emergency and threats to fundamental security.
You want a response? Yeah. Or
I think that's absolutely right and very true. And I think that there's just, the more you get into psychoanalysis, which is what this institute represents, for instance, and the more you accept the kinds of view of human beings that we probably, most of us here, accept, the less adequate the law seems to dealing with its subtleties. And I was Susan Schmeiser put me onto this early essay of Freud's I didn't know from 1906, which was actually an address to a seminar in jurisprudence about the establishment of the facts in judicial proceedings. And he picks up on an experiment that I think Jung began of free association in order to make criminal suspects betray themselves through associations of words. But then as Freud goes on with this essay, it turns out that the kind of betrayal that he has in mind is much more subtle and obviously totally unusable by the criminal justice system. And then a few years later, 10 years later, he writes a little piece called Criminals from a Sense of Guilt, where he says, the justice system has it all wrong. Why do people commit crimes? They have a burden of guilt. Therefore, they go out and commit a crime in order to be punished, right? And so that stands all of criminology on its head. So I think that our real understanding of the way people behave is radically unusable in the law. And I think we've reached a kind of impasse. And I think somehow Guantanamo Bay becomes a metaphor for that, right? I mean, it becomes a black hole of thinking as well about criminality and what we consider criminality, as well as a literal black hole where we assign people. Does that make sense?
Yeah. I don't know, Carol, if you wanted to jump in. I know you had said that you're feeling more like a psychologist and a novelist than a lawyer in this group, but I was wondering in particular your ideas about this relationship between imagination and rationality and sort of that dichotomy being a false dichotomy, perhaps. And
yeah, I mean, I'm sit where Kenji sits on that issue, because I think rationality is an act of imagination. I mean, it's imagining a person very different from what the person we've come to know through psychoanalysis. I mean, this idea of a rationality that's, first of all, even trustworthy, that's somehow divorced from emotion. I mean, that's rational insofar as it is unemotional. This whole universe of, I mean, you know, it used to be called rational man, was an act of was a figment of imagination that was maintained in part by the silences of the person who wasn't imagined to fit rational man, which was first of all women. So that's a lot right there. But also rational man was imagined as white and Western and I don't know, and somehow also divorced from sexuality and passion, all of which were seen as irrational. So, you know, I've been sitting here thinking, I'm enjoying hearing my colleagues who are lawyers talk about this, but I left this discourse a long time ago, and I left it on two grounds. And one is psychoanalytic, and one is really political. And the psychoanalytic one was to take psychoanalysis, first of all, seriously, and where Freud began in studies on hysteria was with the observation of what he called double consciousness and dissociation. That is, we don't even know what we know. Never mind guilt and everything else. And certainly as someone who's done a lot of psychological research and interviewing, if you take people's statements as illustrative of what they really think, I mean, it's completely naive. You know, and in some ways this was heightened for me when I started doing research with, of all people, girls who nobody takes seriously. But you know, you ask a girl a question and she'll give you an answer, like a girl once said to me, I don't like myself enough to stand up for myself, and you can code that low self-esteem or some cliche like that. But if you actually say to someone like that, is that true? Do you really feel that way? She says, actually, no, this is how I stand up for myself. And then she gives you this whole elaborate, you know, how she deals with a world she doesn't feel able to contest. So the idea of taking that rational discourse as rational or as legitimate or something. That is my first problem. And the second is just where I came into this whole thing historically was where psychoanalysts and lawyers and psychologists and philosophers and theologians and the whole were reading culture as nature. And they were reading patriarchy as nature. And that was in my own field, which was psychology, is very intelligent and eminent and basically, quote, good people. I mean, I taught with these people at Harvard, Erik Erikson, Lawrence Kohlberg, interested in questions of morality and trying to combat moral relativism. We're doing studies of humans that included no women. And neither men nor women saw this at the time. That's why I could write about it, because I was there. And basically, it was like, it was so in the culture, it was like, a fish doesn't know it's swimming in water. And we didn't know we were thinking in patriarchy. So I'm looking for how have these shifts in the discourse. I mean, I noticed that on your board at this marvelous center, and thank you for inviting me, is, Damasio, the author of Descartes' Error. So post-Descartes' Error, post the critique, the radical critique of rational man as exemplary of human, I'm interested, what happens to the law? How has the law incorporated? And particularly, sitting in a psychoanalytic center, how does the law deal with this? Because it's not that it's illogical. To me, it's a different logic. That's all.
Isn't there a book called The Irrational Man, Wayne Barrett?
I'm sure there is. But still, that's the same culture too. I mean, irrational man, rational man, this man, that man.
Any man will do.
Every man. There you go.
In a law, it has not only rational, but as Anne said, reasonable. It has to be originally a reasonable man. Now it's a reasonable person.
But it's not really a reasonable person, because in a sense, to the extent that woman has been slotted into the persona of reasonable man. So it's as if you say to women, now you can be like us. And then the question is, well, do we really want to? And
I would kind of resist the label myself if I were you.
But to me, that's the transformative moment, is to say, no, I don't want to just switch my position within the old framework. I want to challenge the framework. I want to create out of this potentially creative moment where all kinds of voices are coming in that were not part of this discourse. And that, to me, is a moment of potential transformation. I think that's where we are in terms of our culture. So where's psychoanalysis in this? Where's the law in this? I mean, that's the exciting question.
What does happen to the law if you start taking Carol's insights seriously?
I volunteered not to come.
I tell you, I think it starts to look like family law is what happens.
And what does family law look like?
Family law doesn't look law-like, actually. It looks a lot like equity. It looks like
That's interesting.
Individualized decision-making, taking account of people's I don't want to use these terms, but
I would ask. One of the things that was very striking to me when I basically critiqued reasonable man law was the assumption, or the presumption, was of the autonomous individual.
Right.
And I thought that was a presumption that could be maintained as long as all the people who took care of these autonomous individuals didn't speak.
Right.
And once they spoke, the individual no longer looked so autonomous.
Right.
So that was the thing about the counter, the different voice, if I use my own term, started with a premise of relationship. I mean, that we are intrinsically, we are relational, responsive beings living in a condition of interdependence. Certainly that seems very obvious right now. That family law would pick that up is very interesting. I mean, they would almost have to, because a family is an interdependent unit.
One of my favorite examples of that is the example of battered women. how the law handles the battered woman. In particular, the woman's, let's say, how a jury is going to handle the question, the issue of a woman who chooses not to leave her batterer.
Well, that's a perfect example.
And the law struggles with that. I think we've gotten to the point where evidence can be introduced that even women who are being battered may choose not to leave for other reasons, many of them psychological. In fact, love may even be a part of it. I mean, that's a hard thing for the law to grasp.
Struggle with the whole notion of false consciousness.
Right. But what's funny is that, Carol, you'll enjoy this, that the law has developed, or was striving to develop the notion of the reasonable battered woman as a way of dealing with this. So, what would, not a reasonable man or a reasonable person, but okay, we'll deal with there must be a reasonable battered woman there who, and so the law is constantly trying to even in the area of family law, where it works the least well, I think, because you have children and dependents and family relationships. It's trying constantly to strive for a framework of reason and rationality.
Or to bring its framework of reasonable person into areas that so deeply challenge that. I mean,
that's one move the law makes. But the law, I think there's so many interesting observations one could make in response to your question, because the law is not uniform. It's incredibly variegated. So there's certain areas of law, historically and still today, that remain very much beholden to reasonableness standards, if not the reasonable man. We may gender neutralize reasonableness to rational actor models. And then there are other areas of law. I mean, we can, it's like a natural experiment. We can look and see what happens when the kind of alternative to a Kantian model of the autonomous individual is incorporated into legal doctrine, and see what happens. I think Anne's exactly right that the first place that we look for examples is family law. It's not the only place. There are other, but it's sort of the most obvious place. But even if we just start there, I think some of the results might surprise you, because I think in some areas of family law, we see, partly in response to theoretical interventions like yours, to the feminist movement, but also in response to earlier efforts on the part of psychologists and psychoanalysts. There are areas of family law, particularly in the area of child custody, where the law has adopted a relational model, a model of interdependence, a model of attachment and connection, and explicitly incorporated that into the doctrine. So you get theories like the psychological parent theory, so that might be interesting. You might say, oh, isn't that interesting? Here's a domain, perhaps a somewhat limited domain of, if you think of all the human activity that's subject to legal regulation, but nonetheless an important domain. And here we do see the adoption of a relational model. An alternative to this isn't about squeezing people into a reasonableness standard or a rational actor model. And although the effects, there are lots of different effects, and some are bad and some are good, it certainly looks like there is a legal, not only recognition but promotion of relationships, of relationality. But in other areas of, even if we just stick to family law, where the consequence of rejecting a rationalist model in favor of an understanding of human nature that is much more concerned with and valorizes and wants to have freedom for the emotions, rather than the consequences of adopting that more romantic picture of human nature being to promote human connection. In some cases, you end up with a far more radically individualistic doctrine. And let me give you some concrete examples to say what I mean. The areas of law in which I think we see sort of the most obvious implementation of a romantic notion of freedom that's not attached to a rationalist picture of human psychology, is all of the areas of law, first of all, dealing with the regulation of sexuality, right? So sexual freedoms, voiding the traditional prohibitions on sexuality, but also in the area of marriage and divorce, the very idea of a right to divorce. Which is, I think, very much a product of the law incorporating this notion of sort of the law of the heart. And it comes to be seen as coercive to force people to stay in a marriage. So the law is, I think, very much influenced by a romantic, non-rationalist model. But the consequence in that case isn't to promote connection. It's quite the opposite. It's to permit a much more radical form of individualism than the more traditional rationalist approach supported and required.
Thoughts? Yeah. Kenji, go ahead.
Oh, thanks. I mean, in some sense, I just to sort of recap what I'm hearing from all of you. I mean, in some sense, I think we would all agree that there's a conception of voice, the truth, the imagination that is going to find much more robust expression outside of the law than inside of it, whether that is expression in psychology or in literature or what have you. I think in some ways it may be too easy a shot to take at the law to say, oh, well, the law is reductive because, it can't take into account all of the complexity of a world that's saturated with novelistic meaning, that it has to reduce things into binaries of guilt and innocence or what have you. I do want to reintroduce the idea of coercion again, because I think that I think family law is a really interesting instance, and I hadn't thought about that. But where I think of where the law takes its most literary forms, because I agree with Nomi that law is plural and there are many different fora, are things where the law has deliberately said we're going to have less force in order to have more voice. So Truth and Reconciliation Commission, right, in South Africa says you get amnesty, you won't suffer any consequences so long as you tell the truth, right? And so that's a trade-off between the coercive power of retributive justice on the one hand and a desire to actually hear the story, right, and to hear the narrative in a relatively unimpeded way. I think that where I am resisting a bit is this idea of thinking about it as necessarily a criticism of law or a kind of stupidity on the part of the law, which I don't think anybody's directly voiced here, but I think gets voiced a lot, of the law is just kind of galumphing along and it's very flat-footed and it just can't sort of quite catch up with the subtlety of the humanities. And I think that there are reasons for that, violence being the prime one of them, but there are other reasons as well. And I guess to sort of sound that caution, I think that there is a real danger in law in respecting the voice. And Nomi touched on one example, but I want to actually tie it back to the Guantanamo example that Anne was raising and that Peter was riffing off of as well, which is to say that if we look at the issue of torture, which is really what we're looking at in the context of Guantanamo, and we look at where in our Anglo-American legal tradition we have seen torture, we really see it before the rise of the jury. So this is my colleague, John Langbein at Yale, who says that there's an inverse correlation between the rise of the jury and torture. So torture declines as the jury rises. And in the continental tradition, which didn't adopt the jury system, we actually see torture surviving well past where it did in England. Now, if you think about what the jury system has provides, or the alternative, if you think about why the jury system would be an alternative mechanism to torture, essentially what you're saying is, where do we locate fact-finding and the truth in a world where God has left the stage or ceded a large part of the stage, right? So we no longer have the ordeals of fire and water where God actually, through his laws of nature tells us whether somebody's a witch or not, right? So what are the locations? Well, one is the person's own voice, right? And that's the path that leads to torture, because once a person has a monopoly on their own truth, then the way in which the state is going to try and get justice when the person is recalcitrant is to overbear that person's will and make the person speak, ventriloquize the state's truth, right? The other location is a jury, which is to say a group of people who are external to the individual, who are looking at the facts and trying to evaluate that, right? So, I mean, if it's not clear already, I mean, my bias has always been towards the jury and away from the idea of the individual, precisely because my love of literature has taught me that the idea of allowing individuals to speak in their own voice and then having that be the core determinant of public use of violence against them is a really sticky wicket. It's a really complicated enterprise, not least because what Carol was saying before about how people often don't know what they know. So one of the things that I think is so fascinating looking at witch trials, for instance, is often the witches don't know until they're dunked in water whether they themselves are witches. So we make a mistake, right, to think that people have a monopoly on their own self-knowledge. Right. Where would the entire Western tradition of psychoanalysis be if we assume that people were transparent to themselves, right? This is Eve Sedgwick's point. So I find that a really dangerous assumption. And I would much rather, for all of its flaws, have the publicity of, 12 people from the community or however you want to call it, looking at that individual and making an external judgment about what kind of violence should be meted out on them. And I think that the real problem with Guantanamo is that we've moved into a confession culture because we've left the jury as we've traditionally understood it behind with the military tribunals and all of the statutes that the Bush administration have passed and to suspend the normal operation of the criminal trial. And we really think of this as different from an ordinary criminal trial. And we've moved away from a form of public justice into what Peter was talking about before, which is really an oubliette. It's really let's throw these people into this pit and forget about them, right, until they speak themselves. And we will make them speak if they don't.
Right. Kenji, that's absolutely right and very eloquent. I just think maybe you're presenting a slightly idealized picture of everyday American criminal justice. Because after all, 90% of criminal cases are disposed of on pleas and never get before a jury at all, right? And though torture is presumably not going on in the police precinct anymore, there are versions of coercion that the police have become very good at using, psychological coercion. If you read the interrogators' manuals, as I know you have, you know that a compliant subject can be made to confess to almost anything. And it's interesting that in that 1906 essay of Freud's, where he gets towards the end, he says, well, you guys in the law have to watch out because the person you take for a criminal might just be a neurotic, and you have touched on one of his sources of guilt, and therefore he has confessed, but confessed falsely. So I think the notion that there is this opposition between the inquisitorial torture system and the jury system is true in an ideal history, but not necessarily in a real history. I remember, as we both know from John Langbein, torture originally came into the justice system in early modern Europe as an advance, as a more scientific form of proof, right? Taking the place of medieval ordeals, putting your hand in the fire, or trial by combat, or throwing a woman in a pond to see if she would sink or swim, which would prove whether she was a witch or not. So this was considered a higher level of proof. And there still is a sense in which what is produced by a suspect's own mouth, from his own lips, is very hard to go behind. Once someone has signed a confession, usually written for him by the police, it's very hard to undo that confession, even though it's been well established that a large percentage of them are false.
Look, can I pull against that a little bit? So I don't think I have an idealized vision of criminal procedure. What I think, Peter, is that what we're really talking about is always imperfect justice, but degrees of imperfect justice. And what I think of the criminal procedure system as we have it under domestic constitutional context is that there is always the promise of a jury, right? Which is to say that if you don't plead, you can get to a jury in a criminal trial. That's a Bill of Rights guarantee.
If
right? But
if you know that, right? Well, if you haven't waived your right to counsel, which 85% of criminal suspects.
But I want to draw a sharp distinction between that and what's happening in the Guantanamo context, because the downstream consequences, what happens downstream has a relationship to what happens upstream. So if a prosecutor knows that I can get to a jury if I want to, right, if I hold out, that prosecutor is going to treat me very differently if the prosecutor knows that I can't get to a jury, right? And so it actually has track-back effects to things that happen much earlier in the criminal process. So neither of these things is ideal, but we can say, I think, pretty definitively, and I don't think you would disagree, that one is better than the other. With respect to the idea of torture as being an advance, that's obviously a correct historical statement. I think that one of the things that is particularly terrifying about that is the kind of scrupulous adherence to the idea that something that comes from a suspect's own lips is dispositive. So confessions are the queen of proofs of the common law, right? So the greatest proof that you can give is to actually confess. But this leads to all kinds of ripple effects with respect to what lengths the state will go to in order to extort that confession from an individual. So, I think many of you are familiar, I think it's pretty familiar history, that usually you couldn't convict somebody based on or charge somebody based on a confession that was extorted from them while they were under torture. But if they recanted on what they said under torture, they could be tortured again, right? So there was an infinite number of times that you could be subjected to this. So ultimately, you would just say, okay, I give, and I will say whatever you want me to. And this is something that we know from modern history. I mean, Jane Mayer's fine book, just published this year about the torture state is really about the idea that people will say anything under torture. I'm actually working on, off of a seminar that Carol and I co-taught, a book on Shakespeare and law. And one of the things that's really interesting about Othello is I think that it isolates this dilemma, because Othello always errs when he tries to fact find on his own or consult only with Iago, so the handkerchief, whether or not Desdemona is cheating with Cassio. In that play, however, when there's collective decision-making, like the Senate at the beginning of the play or the Venetians who come in at the end, they're actually very good at collective fact-finding. So they know that the ships are sailing to Cyprus rather than Rhodes. They know that Othello didn't bewitch Desdemona. They know that Iago ultimately was responsible for the crime. And I think that one of the things that we need to really see in that play is that last moment when one of the Venetians says to Iago, "Torments will ope thy lips," after he says, "After this day forth I never will speak words," saying, "I'm not going to confess." And we know that torments are not going to open his lips because he doesn't really know. I mean, that play is not about his motiveless malignity. It's about he has too many motives, not too few, right? So he doesn't know why he's doing what he's doing. He doesn't know why he's evil. Right. There's so many things that he says are his motivations. He got passed over, he's a lower class person, or is deemed to be such. Othello's sleeping with his wife, Cassio's sleeping with his wife. By the time we hear that Cassio is suspected of sleeping with Emilia, we think this guy has no idea why he's doing what he's doing, right? So I think that really is a play which is occurring exactly at the time when we're flipping away from a torture regime to a collective justice regime. That's actually thematizing the idea that individual confessions are not that trustworthy, and that we actually need to engage in more collective decision-making once we've let go of the idea that God or the laws of nature are going to do this for us, either by the ordeals or trial by battle.
What if you added the Winter's Tale to that?
Absolutely, yeah, and the Witches of Macbeth, and I mean, there's a huge riff that you can play on that. Yeah.
I guess I wonder, I just wanted to pick up on this notion of voice, because it seems to run through a lot of the comments here. And I think you're absolutely right that confession is a pretty complicated moment in an individual voicing either a truth or not a truth. But there is a way in which the Guantanamo Bay detainees themselves are seeking to voice their situation. And there's a way in which our traditional notions, of the autonomous individual self are about the dignity and the worth and the ability of including women, right, to come forward and speak. And of course, Freud invented the talking cure. So there is something about I think that the traditional rule of law idea, due process idea, captures about the importance of the individual being able to self-expression. And that's, of course, our basic civil rights, is the right of individual autonomy. It's been an engine of the civil rights movement for women, for minorities, over the last few decades. So to dismiss it out of hand seems to me problematic, both in terms of that kind of a political agenda, but also to dismiss the notion of individual autonomy or voice.
Inalienable rights.
Liberal rights, that they may capture some truth, not the whole truth, but some truth about both who we are as individuals.
And they're
also,
better than having no rights. Right.
It's maybe the best of some of the choices available to us.
Actually wrote about that.
But you know, when you talk about Freud inventing the talking cure, one of my students at Harvard, when I basically said this, said, no, it was the listening cure. And I thought that was really interesting.
The listening cure.
It's the listening cure, because in the absence of listening, or you could say resonance, the voice doesn't come forward. Mm-hmm. And I mean, what that amazing demonstrations of studies on hysteria of Freud was when somebody said, in this case, these were women in studies on hysteria, Fraulein Elisabeth von Ar, and she would say, I don't know. Nothing is occurring to me. And what Freud did is he would see the signs of emotional, just the signs on her face, and his response was, you do know. So he was overriding her voice, but at the same time undoing an initiation which had led her to give over her voice to the voice of her father, who wanted her not to know what had happened, for example. And he wrote in the case, I think it's another case in studies on hysteria, I think it's the case of Lucy, one of the others, the patient knows everything of pathological significance with respect to her symptoms, but she doesn't necessarily know that she knows it. And, the diagnosis in the case of Elizabeth was her love had already become separated from her knowledge. Now, this is basically what I'm saying here, which is the notion of voice is very complex. It's absolutely layered. It seems to me that's so fundamental to any psychoanalytic point of view. There's not a voice, there are voices. And which voice comes forward is very contingent on the kinds of resonance that voice finds, whether it can be in fact heard and understood. And in the absence of resonance, voice tends to go into silence. It goes into the body. And, you use the term romantic, and I was sitting here thinking that in Damasio's book, Descartes' Error, his term for a voice where reason has been dissociated from emotion is not romantic, it's traumatized. Because he shows that to be the result of brain injury or trauma. And it seems to me that what psychoanalysis says also, in effect, at least through my interpretation, is that when a voice is traumatized, this is the work of Ferenczi, it's the work of Ian Suttie, that it goes out of relationship and into silence. This amazing paper of Ferenczi's called The Confusion of Tongues Between Adult and Child, that is, when one person experiences his or her voice as ineffective, as overwhelmed, there's a tendency to take on the voice of the more powerful person, that is the voice of the aggressor, and to come to hear it as one's own voice. And that makes these notions of voice and autonomy so deeply unreliable, because basically we take the traumatized person's voice as the truth, when in fact underneath that is a voice that is carrying the truth, and it may be actually not even on the voice but in the body. And it requires the only way you can undo dissociation, and I think this is my deepest question in this panel, is not through logical argument. You can't argue your way out of a paradigm. You can't argue your way out of dissociation, because the logic of the argument is within that dissociated framework. The only way is through association. That's, of course, what every psychoanalyst knows. It's the logic of dreams, it's so forth. So how can that insight be brought within the framework of the law? It's my question for my colleagues here.
Well, this is not an answer, but just in this free association. You were talking about the reasonable battered woman as a concept that family law had come to. And it reminded me that in some rape cases I've studied, there's a question of reasonable fear. Since some analysts have shown that of all the emotions in the world, fear is the least based in reason, or the least that can be attributed to reason, the whole notion of a reasonable fear has to be reinterpreted. And there are some judges who have recognized that and said, it's not a reasonable fear we're talking about. It's calculations on the part of the aggressor or the rapist, which can be reasonably assumed to induce fear in the victim so that she complies. But that there again, the way reason comes into criminal actions and criminal law strikes me as very problematic and subject to the kind of caution that Carol is urging. Though, if you put Carol and Kenji together, Carol would disable Kenji's profession entirely. There would be no more judging, right?
How so?
Because there'd be no basis on which to pass a verdict. Right. It seems to me. Right. It would be too layered, right? And the law has to adjudicate. I mean, that's its role.
Well, Carol, I wanted just to come back to because
we taught together for a whole term.
Where did you come out?
With Kenji's book on Shakespeare.
I wonder if it's possible to say that, to draw some analogies between the psychoanalyst and the lawyer, or perhaps the lawmaker, or the law as a figure. Because when you talk about dissociation and the need to mend that somehow through association, right. I think at least Freud, and I don't know if later analysts would all agree, probably not, they're like lawyers, they don't all agree. But at least for Freud, I think that process of associating was really the process of bringing secondary processes to work on the primary processes. That it was reason that was the driving engine behind association. And Freud himself, well, we wouldn't exactly call him a rationalist. There was something very reason-oriented about his endeavor, his work, how he viewed mental health, which I think was about strengthening the ego and the ego processes. The whole notion of a therapeutic cure in psychoanalysis seems to me about the triumph of the ego in a way that we see in law. This maybe unconscious need to have the triumph of reason. And so I know, I worry about, I guess I wonder about in the individual sphere, dissociation is certainly a very painful place to be. As is, it's even going further, some kind of total disintegration of the self into psychosis.
Dissociation is a very protective way to hold on to what you know in a situation where you can't know it. It's a brilliant but costly move. Freud is working within the framework that Kenji introduced at the beginning, that is of Plato, where you have the horse and the rider and the reason and the da-da-da. But he's also doing something that I think, and what I'm not choosing emotion as opposed to reason. I'm rejecting the split. Mm-hmm. So I think that has to be completely clear. I'm talking about the limitations of that paradigm in light partly of the insights of psychoanalysis, as well as subsequent research in neuroscience, notably Antonio Damasio's work, and also work in developmental psychology, including my own work and other work like that. But the thing that Freud also did, and I think this is where it comes closer to the kind of radical move that interests me, is he said that, when you could make judgments about certain acts or whatever, or see them as not rational, and yet there is another logic, a psychological logic, which is different from a formal logic or deductive logic, and yet is also equally, let's just say, systematic, equally, quote, logical. And if you understand the psychological logic of an act, then it's not that you abandon judgment, or but how you judge, or even the questions you ask, or the actions you would take would be very different. So, for example, some of the examples that Peter gave, if you have somebody who is seeking punishment because they are carrying some, say, feelings of guilt that they are not even consciously aware of, they're not even you could punish them, but that's not going to stop the behavior. So if your goal is to stop behavior you see as destructive, whether it's to the person themselves or to another person, you have to understand what is the logic that's driving that behavior. And what I think psychoanalysis did is it gave us a third term that's neither rational nor irrational in the reason-emotion split. It said that this behavior has a rationale. It has a logic, but the logic is a psychological logic. And one of the things that amazes me is the extent to which, in contemporary conversations, including the question, is it nature or is it nurture, the psychological has dropped out. And I think if there's a reason to say why there's a need for psychoanalysis at the present moment, is that so many of the most difficult issues which the law and society and we as individuals are really struggling with right now really require an understanding of that major insight of psychoanalysis.
Can I respond to something that you said earlier, Anne? So I took it as a really useful point where you said, we do celebrate voice in this culture, and we should be careful about jettisoning that too quickly. I want to formulate my point more clearly and say it's actually precisely in part because I value voice so much that I want to protect it from too much legal intervention. So one way to make the point would be to say, when I teach law and literature, sometimes students come to me and say, I love law and I love literature, and that's why I'm not taking your class, because I don't think that these two things are ennobled by each other's company. So it's like the Balzac line of, I love soup and I love woman's hair, but I don't like woman's hair in my soup. So it's not everything is going to be improved because it's mingled with something else that's valuable, right? And so I do think that part of what's going on when I say I would much rather have third-party jury-centered fact-finding rather than first-person confession is that I think that first-person confession in our culture has a really privileged status that could be undermined by its overuse in the legal context. So I'm cribbing now from Peter's book, Troubling Confessions, but one of the things that happens is that if you look at literary confession or psychoanalytic confession or religious confession, those are much more forgiving with respect to what the actual fact of the matter is than legal confessions are. So if I'm in a therapist's office, if I'm in a church confessional, if I am a literary memoirist, although with James Frey and Rigoberto Menchú, I think we have had our go-around with what standards should be applied there. But at least with respect to the first two, and probably with respect to the third, at least as a relative matter, we're much more forgiving about people saying, this is what it felt like to me. You might not have seen exactly this happen if you had been there, but this is what I saw, And that people don't even need to enter in all those caveats. And it's very, very dangerous when that, because there's something so productive about that form of free association, of imagination, of dreaming, of wishing, that reality were a certain way, that it's very useful to hear people's stories and suspend the part of you that is, the fact finder, did it really happen that way, and I'm going to cross-examine you, and I want an affidavit, and I want a deposition kind of mentality, right? And I'm really very worried about toggling too quickly from the literary, the psychoanalytic, or the religious confession over to the legal confession, because the legal confession has very, very different standards, but the poly at large may not know that. So
Isn't the Truth and Reconciliation Commission that you brought in an anomaly in that regard?
it is. It's absolutely an anomaly. But it's an anomaly for this reason, which I also brought up before, which is to say that's a law denuding itself of coercion, right? So at the point where, I'm going to go back to an example that a case that Peter cites in his book and discusses very persuasively called Brewer. And in Brewer, what happens is that a person is suspected of killing an individual, a little girl in Iowa, and he has to be transported from one part of Iowa to the other. I think it's Davenport to Des Moines, is that what it is? And so the police officer is driving him through the snow, right? He has promised that he will not question this individual until they get to Des Moines, where the suspect's lawyer is waiting, right? So the snow is falling and falling, and the police officer says, "I know you're a religious man," which the suspect was. And the suspect was also had some cognitive problems. I mean, he was not a very high-functioning person with respect to IQ. And the police officer said, "Well, the snow is now falling, and I know you're a minister." And he kept referring to the person as reverend or minister, and said to the suspect, "The snow is now falling that we won't be able to find the little girl unless you tell us where she is. And don't you think she deserves a Christian burial?" And the man then says, "Okay, I'll show you where the shoes are, and then I'll show you where the clothes are," and then finally shows her where the girl is, and then is convicted of murder. This goes up to the Supreme Court, and the Supreme Court reverses, saying this is too much. Christian burial speech was too much of a trigger, right? But notice what's happening there. Religious discourse of confession is being deployed by the law in order to extort a confession that has very different consequences from what a religious confession would have had, right? So by creating the psychic space of the confessional, by saying, "I know we're both religious people, and don't you think she deserves a Christian burial?" you're citing a lot of cultural material that says this is a safe space, this is a therapist's office, this is a confessional, right? You can actually tell me, and I will interpret that in the light most favorable to you. I will not use it against you, And the reason that we have the Miranda warning, or at least a bit of it that says anything you say can and will be used against you, the will be used against you is the circuit breaker, or supposed to be the circuit breaker between all these other forms of cultural confession that we have in the legal form of cultural confession, where we snap out of the, we are on the same side here and I'm trying to help you, the therapeutic confession, to the legalistic prosecutorial confession. And that is a real problem. I mean, it's a real danger. And so when I say...
The Supreme Court reversed.
Reversed, ultimately, yeah. But when
it stuck back in again. They allowed the evidence of the body under the doctrine of inevitable discovery, which I love.
I remember you talking about it. I just want to jump in to maybe add to the conversation, because I think that confessions are extremely important. They're illuminating. But even within the terms of the legal discourse, we can see there's ambivalence. There's a troubling, increasing reliance on confessions, and yet it's not as though the law doesn't know the problem with confession. But I think some of the more general questions that you've asked, Anne, if we think about another kind of, maybe even more within the law, paradigmatic kind of speech act that's performed by people who may or may not be properly conceived of as rational actors or rational autonomous individuals. I wonder what happens if we shift the discussion, as important as it is, from the confession, but suppose we think about what I think is an even more firmly established normative speech act in the law, and that's the speech act of contractual commitment, right? Would that we had as much legal awareness of the kinds of problems all of you have adduced with regard to the voice of the person who supposedly is making a confession. Would that we had that same degree of skepticism with regard to individuals making contractual commitments, whether it's in the context of economic contracts or switching back to family law, all of the different, the marriage contract, prenuptial contracts, agreements that may be more or less formalized between parents about the upbringing of their children. I think if we focus on that kind of speech act, that we can get some interesting purchase on the basic question that Anne raised, because you see an interesting selectivity in the law. In some areas of the law, it looks like the law is continuing to adhere to this very traditional rational actor model. But again, going back to the example of divorce and other, there's a place where the law, it seems to me, has accepted the psychological logic. It has, for centuries there, for all intents and purposes, was no right to divorce at all. Then for a very long period of time, it was extremely limited. And then we saw this process of the steady liberalization of a right to divorce, culminating in no-fault divorce, right? It's just kind of a person can, just any one person can just exit at will, right? It's sort of employment at will, marriage at will, right? Anyone can leave at any moment, to slightly exaggerate. And it seems to me that's a perfect reflection of the law coming to, and it was a very, very radical transformation. But part of what it shows is, Kenji, I think you're exactly right to say sort of the touchstone here should be coercion. But what counts as coercion, as opposed to an expression of individual liberty, is going to be radically different depending upon which of these two competing models of human psychology you adhere to. From the psychological standpoint that most of us share today, it would be completely coercive to require people to stay in a marriage against their will, whatever we might think about other ancillary issues. But from the standpoint of, sort of the traditional rationalist Kantian model of the individual that prevailed for centuries, and if we wind the focus to think about the right to divorce alongside other romantic and sexual freedoms that the law came to grant, from the more traditional rationalist perspective, sexual freedoms, what we call the freedom to follow your heart, is not freedom. It's being enslaved to your passions. And there's still people who adhere to that traditional moral psychology, which is a rationalist psychology, although it may not seem very rationalist to us. And I think that's a very concrete illustration of how it actually does make a difference. There is an important distinction to be drawn. It actually has practical consequences with regard to social policy and legal doctrine, which of these psychological models we adhere to. From the standpoint of one model, following your heart, following your passions, emotional freedom, sexual freedom, romantic freedom is true freedom. And from the standpoint of a more traditional psychological model, that's not freedom, that's being a slave to your passions. And I think that's a distinction, that basic distinction, that may seem totally outmoded, but if we shift our attention to issues like addiction, or we think about economic contracts, all of a sudden a lot of us might find ourselves gravitating towards the more traditional rationalist model. So I actually think there is a real distinction to be drawn. It's not a false dichotomy, and it comes into view when we think about what are the circumstances in which the law is perfectly willing to allow people to breach contracts, break vows, without any penalty, in contrast to the situations which supposedly are the normative situation in which the law insists on enforcing contracts, and even if it permits breaches, still, there must be a remedy for the breach, which is not the approach we take in marriage law at all.
No, I agree with that. I don't want to just be a negative voice here, but you're talking about a processual and negotiation filled part of the law, which has made positive advances. So God knows it took a long time. And I mean, though there was no divorce for many centuries, men were perfectly free to do what they wanted, right? It was women who were held in the marriage bond, essentially. I mean, men were in traditional European societies, particularly in the upper classes, free to commit adultery as much as they wanted to. It wasn't even considered adultery. So there's a dark side of that, but I'm also interested in and this comes off the confession, but the surveillance society that we are in the matter of producing. I mean, I was at University of Iowa Law School yesterday, and the question of being convicted by traffic cams came up, and whether this was a completely objective view that could not be disputed. And someone who knew more than I about film said, no, you could take those pictures from different angles and come up with very different views as to whether you had really not stopped at the red light or not. And Washington, D.C., for instance, is full of these things. And every time you use your Easy Pass, if you're going too fast, you'll get a little message by email saying that we caught you. And criminal interrogations now are more and more being videotaped, but videotaped under conditions set by the police. They usually don't turn on their video cameras until they've got the suspect in a position where he's ready to confess. I think Minnesota is the only state that insists that police turn on their video cameras as soon as they make contact with the suspect. So we're creating this whole world of sort of pseudo objectivity, which goes beyond voice, and eventually it will be, I suppose, supplanted by the non-visible, by DNA testing. Though you saw that article in the Times today that most crime labs around the country have several years backlog of material that they're supposed to test for DNA tests. They just haven't gotten around to it. They don't have enough personnel, enough money, and so on. So anyway, this is not going anywhere except to say that I think there, as well as the negotiation model emerging, there's another model of sort of pseudo-scientific conviction of people, which is also emerging.
I just want to make a couple of comments. I wouldn't like it to go unsaid that Freud's paper on criminals from a sense of guilt is a very early paper and therefore somewhat simplistic. The modern psychoanalysis would not assume that a behavior as complex as committing a crime would have just one motivation, and that will be some kind of guilt that one feels, whatever guilt may be. And so, just like the other paper, those wrecked by success, it's kind of nice, especially in one's early career, to think, oh, gee, I found the clue here. Every time somebody tells me about something bad they did, they must be feeling guilty about something else. It's a little too easy, facile. But, it's early Freud. But isn't it true that in law, at least in this country that I have, observed for the years that I've been here, and which I think compared to many other countries is a pretty fair system, that a lot of the psychology is taken into account, and that's why there are all these protections within the law, such as the jury system and such as the due process and all that, that are recognizing that, even the prosecutor can hide the DNA evidence in order to advance his own career or whatever other reasons he may have. So we do recognize the role of psychology and the individual's own issues in law.
Well, I think that's very fair. I think actually Kenji's probably writing about that now, the ways in which it's not just an all or nothing system. The rule of law is not there's a second voice happening in the law, in dissents and in exceptions and in alternative rules or equity or however one might want to put it.
But also staying entirely within the role of criminal procedure, I think one of the most important stories that the state permits the individual to tell is the silent one. That the right against self-incrimination allows people to remain silent and does not extort confessions from them when they prefer to remain silent. And I think that I mean, silence is very powerful in theater on the stage, and it's very powerful in criminal law.
Which is, I think, why in Guantanamo they've stopped those things, because essentially they're acting like there is no psychology there. But that's not true the way it is, let's say, in a court in New York.
Right.
Well, I think it depends. I mean, I agree with what you said, and I would extend it back further. And if what we're talking about is a theory of the psychology of the law enforcers and the adjudicators, and I think it's very fair to say, I don't know how unique it is actually to America, that there is a theory of the psychology, it's really more than anything a cognitive psychology of the people who are entrusted with the task of enforcing the law and prosecuting people and reaching convictions, you know, all the different people who play a role in that process, from the investigators and the police and the judges and the jury members, where the central conclusion, you know, the cognitive psychology of the law enforcers tells us that we collectively, you know, maybe collectively we get it right better than any individual, but that we're prone to get it wrong. We can never eliminate the risk of error. And I think it's precisely that psychological theory of the limits of knowledge of the law enforcers that leads directly to the framework of, and it's an emotional, absolutely. And so you can, but that's a theory about the psychology of the people who have to apply the law and convict people. And so sometimes, but if we're talking about the psychology of the people who are the subjects of the law, whether it's the criminal suspect or whether it's people who are subject to the regulatory regimes of economic contract law or family law, there, you know, I think it's a mixed story. I think sometimes the legal system has been willing to incorporate the insights of psychology with regard to what's going on in the minds of the people who are the subjects of the law, but there's also been an enormous amount of resistance to accepting those stories, and sometimes for very good reasons, but sometimes to bad effect.
I just want to, because it occurred to me when you were speaking too, the term "the psychology," I always want to know what psychology, because there's not just a psychology. But when you were talking about juries, and I thought, you know, there was this remarkable short story that turned into a play called A Jury of Her Peers, written by Susan Glaspell early in this century, in the last century, in the 20th century, you know, where a woman is brought to trial for murdering her husband, and the idea of jury of her peers was that her peers were other married women in the community who could understand what had happened in the situation, which presumably the legal establishment couldn't. And so these juries of her peers, that is, the other women in the community, withhold the evidence. I mean, basically they destroy the evidence, knowing that if the evidence was brought in, people wouldn't understand the psychology that was at work because another psychology. So I really think we have to be awfully careful about assuming there is like the psychology or whatever, because exactly it goes back to what I said before. I mean, we're so aware at this moment in history of what the stories we have heard and retell, and then the stories we know but we don't tell, and that have not been part of the discourse. And you know, it's a wonderful moment for a real bringing together of the deeper insights of psychoanalysis, and as I said, joined now with neuroscience and new information about psychological development, with how do you create a normative ethical system that is in fact fair and just like the legal system.
And I'd like to connect that back to what Peter was saying earlier about the surveillance state, because I think what's so beautiful about the jury of her peers story is the idea that, I think it's Holderlin who says, the danger itself fosters the rescuing power.
Right.
So the idea is that the very faculties of perception that allow the woman to detect that this woman is a murderer also are the very faculties of empathy, right? Because it's precisely because they have been there in her situation that they know that she's committed the crime, even though the men don't know it because they are not within the domestic space that the women have occupied. But precisely because they've been there, they also have the empathy for the woman who did it and therefore nullify, right?
Exactly.
The conviction. And so I think what's so daunting, Peter, about this idea that we're moving to a surveillance state where machines are surveying us in this really fine-grained way is that the state's posture towards us has moved from being that of a playwright to being that of a novelist, right? The state really can see us in this really minute, fine-grained way, but without the Holderlin check, right? Which is to say that it can do it without any guarantee that it has a novelist sensibility, a novelist understanding of the human condition or interest in the human condition, or a novelist compassion for us, you know? And I think that is very, very frightening.
Can the moderator exercise her coercion and switch now to getting some questions from the audience?
It's a beautiful place to start.
It was really wonderful. And someone will approach the microphone, I guess.
They have to approach the rules. They approach the microphone. They say who they are. And then they ask their question.
I thought there might be rules.
Rule of law.
Michael Sachs. I graduated law school over 40 years ago at this point. And it seems to me that one great change that has occurred over the years has been the creation of alternative dispute resolution. And that while it may not have as much direct applicability to the criminal side of things, although certainly the Truth and Reconciliation Commission is really a form of alternative dispute resolution, certainly in the issue of family law and contractual law, the idea of not having things decided judicially, but in a way having the parties come together sort of brings in relational aspects of it, psychological aspects of it, and that to me has been a very significant change of how the law has reached out in recognition of the psychological elements.
You know, one of the interesting things in family law with alternative dispute resolution, which was early on a movement towards mediation in family law, which was bringing the husband and wife together, although it's called mediation, unmediated by attorneys, was that it didn't always work out so well for the woman. One of the parties, which is usually the woman. So I guess I'm sounding like a real traditionalist with my rule of law theme, but there is a way in which the legal system does provide some protections for those whose voice may not be heard as well in a less formal or structured way. So.
I'm Henry Earle, and I share your concern that psychoanalytic point of view has lost traction in our culture. When, for instance, in the introduction, Jerome Frank's work in 1930, and I've been going back and looking at John Dewey recently. There was a different mindset in the 30s and 40s. Now, one thing that, as you speak about the range of the law, that I wonder about is whether because we live in such a heterogeneous environment, whether we try to use the law to do things that it's probably not suited for. For instance, one of the great ways of reducing legal action in this country was to repeal prohibition. Suddenly a whole range of things were no longer legal concerns. And as you talk about marriage, there are a lot of people who escape the law by simply not getting married. They live together, they do a lot of the things that those of us who are married do, but they don't put themselves at risk of the law. So perhaps the law has tried to encompass too much. What do you think?
Well, I think it's a well-taken cautionary point, although, you know, in the same way that you take exception to sort of totalizing the psychology, I'm not sure if it's the law that's trying to do too much. People go to the law And so, an interesting case in point, apropos of your particular illustration, right? The movement for gay marriage. We were just talking about this in, I don't know if that's a green room that we were sitting in. But the very lively debate, both within the gay community and without, about, it's a curious moment when the radical emancipatory thing to do is to get legally married. Right? And that, maybe say no more, since time is short.
But don't some other laws have something to do with that, such as getting insurance?
Well, absolutely. So, I mean, you talk about being at risk of the law, which is a very well taken point, but people who you say are married in every respect except legally are at very real risks of many, many different kinds, and it's precisely for that, well, that's not the only reason why, but that's one of the very, very strong arguments in favor of the movement for legalizing marriages.
But that has neither to do with law.
Excuse me, we really have to stay with it.
Yes, this comment or this question is for Peter Brooks. It has to do with guilt. I enjoyed your discussion on that. And also, what reference to me was the book that O.J. wrote, If I Didn't Do It. Can you hear your comments about did he express guilt, no guilt, what?
All right, that's just grammatically an amazing title, right? That takes us back to Dostoevsky. That is a form of confession, right? But one that wants to avoid. It reminds me of the elder Karamazov, who's always sort of in a state of abjection while saying that he's a man of honor and so on. Very curious. And that book, I mean, of course, we never read that book, right? Because it got suppressed before it was published.
No, it's out.
Yeah, you can, if you want to read it, you can get it, I'm sure. I don't. That's an interesting question.
Hi, I'm Bob Herbst.
Yes.
I'm a civil rights lawyer who's been trying cases to juries for a long time. I've tried them as a prosecutor in my early career and as a defense lawyer, but for the last 25 years I've basically been representing victims of discrimination or official misconduct, police brutality and so forth in the civil justice system. And one of the things that a victim loses is his or her voice responding to you. And the victim uses the law in part to regain his or her voice and dignity.
Right.
And so and the trial lawyer is in some sense an alternative voice, hoping to persuade the jury of the logic of the case. And it's not, I don't think conceive of ourselves as rational actors in the process or imaginative actors. It's a melding to try to expose the logic of justice, not rational reason or passion, but to engage both in a way that will persuade the third party finder of fact that the right result is to vindicate the rights. And so there is a great unity, and it should be conceived in that way. And the interesting thing about the jury is that in the civil side, we're the only country left in the world, essentially, that guarantees a right to jury trial in a civil case. And that is fundamental to the ability of our system to protect those rights and to vindicate those rights. And I'm not sure people realize that. And what has been happening in the last 25 or 30 years, as judges have become more conservative, and even juries more conservative, there's been an effort to confine the discretion of juries to do what they think is right. And the rules and logic of reason has, in a sense, been misused to constrain the ability of jurors to do what is right. And And hopefully, this may be an opportunity to try to redress that balance. And so, this was a very interesting discussion to someone who's sort of down in the trenches.
Is there anyone wants to comment on this?
Great. I'm Alexis Quinlan. I wanted to ask about further about the jury of our peers, because I think I've always considered that is sort of it's rational. The women are making a rational decision about the entire circumstance, which maybe only those women can understand. And in that way, I'm also revealing I'm a real tourist here, but in that way, that the Freudian stuff seems to me also very rational. That there's a rationale to our minds and to the stuff that looks irrational, but in fact, it's not at all irrational. It's very rational. It's like math, simple math. So I'd like for you guys to address that. Oh, and one other thing, that in that way that we have a shift in our imagination about how we understand rationality at this point, sort of post-Freud, and like we're having with marriage. I think the last judge who wrote the argument on Connecticut or California, I don't know, and he really talked about we're changing our imagination now these days. That's why this marriage, I'm going to allow this, that marriages can go between whoever. Thanks.
But the rationality in the Glaspell story does result in the destruction of evidence, which is clearly a crime, right?
Yeah, but it wouldn't have to happen if more people understood rationality. If the men had a handle on the larger rationale.
They
had to hide it from men's stupidity, men's irrationality.
But I agree with you. But I think that story ends in more of an impasse than you're indicating, right? I mean, there are two different systems of justice going on, and you're defending one of them. But there is another one which says, a wife killed her husband. What are we going to do about it?
Because he strangled a bird.
But he
strangled a bird, right? But it's not grounds for strangling your husband or not.
Yeah, I agree with you. I think it's because, or maybe I agree with the last point you make. It's a story about two competing systems of justice. The women in that story, everybody in that story has two different kinds of judgments to make, and I actually think it's helpful to distinguish them because we've talked about both. There's the fact finding, right? There's the finding of fact. That's the whodunit. Who killed this man? And the answer is she did. And then there's the moral judgment, which is whether it's a blameworthy homicide or not. And their conclusion is implicitly that it isn't. And now the fact is, the established legal system also not only distinguishes between the factual question and the legal question, but it too doesn't deem every homicide blameworthy or equally blameworthy, and arguably it's within the standards of the standards of justice of the established legal system to exculpate her. But they know that it's the good guy problem. The actual men who are going to be applying the law aren't going to get it, and they're actually going to make the wrong normative judgment, and they're not going to understand, as they should, that she should be exculpated or guilt should be mitigated or what have you. And that's why they hide the evidence. So I don't think it's simply nullifying justice. It's that there's two competing systems of justice, or it's a confrontation with the biases of the people who are in charge with administering justice, to which they respond.
That's what I learned from my new colleague Peter Singer is called esoteric ethics. That is things that you can do in private that the rest of the world should not know about.
Can I just say one thing very quickly to that, because it's a story I love. I think that before we determine whether or not an answer is rational to a particular question, we have to know what the question is, right? So if the question is, did this woman kill her husband, then the rational answer, which the women in the story are obfuscating, is yes, she did, right? But if the question is, did this woman commit some moral wrong in, killing this person that should take her beyond the pale of humanity and force her to be thrown in jail for the rest of her life, then the answer is no. And I think that the reader is supposed to empathize with that. So, I mean, in some place, it goes back to the civil rights lawyers, the gentleman earlier's point, which is to say that I think that a lot of this is terminological, but I think that one thing that we're all tilting against and resisting is this idea that if you subscribe to rationality, there can only be one right answer.
Yes.
Right, and that's a unfortunate legacy of Enlightenment thinking, right? Which is to say, it is like the geometric proof in the Mino, which is to say, there's only one way that there's only one way to draw a square, right? Which is to say, it has to have 4 right angles, and I think that that's really a problem when it gets to questions that are more complex than arithmetic or geometry. Now, what I think is really interesting in what the gentleman earlier was saying is that it actually goes to Carol's point earlier, because if you want to say that there's a logic external to rational logic as traditionally construed, one way of framing that would be to say, well, that's justice, right? Because justice is a system, it's systemic thought, like we have moral intuitions, but justice is something different from pure logic or rationality, right? So that might be another sort of arrow to put in your quiver on that front. But we could alternatively say, and I'll just stop with this, that these are just, I don't know whether it's better to frame it as rationality versus justice or whether to frame it as either 2 forms of justice or 2 forms of rationality. That to me seems, or 2 forms of justice or 2 forms of rationality, that seems to me to be, that is for me an open question that I haven't had answered yet. In this.
The alternative formulations, justice is a unity of the rationality.
Right, and emotion, or, right, yeah.
And it's the logic of it is to decide what's the right thing to do.
Right.
To answer the particular question that is posed.
Right.
And the question is, I think, is neither of the two in the novel, book that I haven't read, but it's really what should be done with this book.
Yes, exactly.
That's the question.
Right.
And the logic of justice is that everybody gets together in the courtroom, if you have to decide that question. And you bring to it a unified, integrated whole, personality and culture to decide that question.
Right, but in the world of the story, I mean, women aren't allowed on juries at this time, right? And so what we have is the question of guilt and innocence being decided by a jury of her peers. One of the things that they get mocked for by the men in the story is they're wondering when they're looking around the murder scene whether or not a particular quilt that she made was quilted or knotted, right? And the last question of the story is the men sort of derisively saying, oh, so did you figure out whether she quilted it or knotted it? And she said, and obviously the words quilt and knot are, guilty, not guilty, right? So it's a pun off of that, and they say, we think she knotted it, and that's the end of the story. So it's a shibboleth that they pass between among themselves because the men don't understand that some larger question of guilt or innocence is being decided, and it's not just a narrow question of what happened to the quilt.
Right, but that's why I added at the end sort of the culture. The culture has to be mature and integrated as well as the individual personality. Otherwise, you can't have a really just system.
Right.
But I really liked your psychological insight that the person who has been traumatized does not have a voice, and that's the function of the lawyer, is to give voice to what can't be voiced otherwise. I think it's really, that's a lovely point.
The system can only provide money. The civil justice system, the only thing it can give to the victim is money, but many clients are less interested in the money than the vindication that is provided by a jury saying your rights were violated. That alone is worth $1 million. And even when, in most cases, of course, it's settled, but in the act of settlement, there is vindication as well.
Go ahead.
I'd like to switch gears a bit to talk about one of Judge David Baselin's decisions made some years ago on a court case in which a school district was suing for the right to present alternatives to Darwinian evolution in the classroom. Baselin looked at the case very carefully and decided that he could not support the school system's position because it was based completely on a religious conviction rather than any rational, what we would now call rational coherence with the Darwinian evolution based on scientific evidence. And that raises an interesting question, because the court, the defendant, which was the school district, defended his position on the grounds that they didn't care what anybody else believed. They had the full conviction that the Bible's version of creation was valid, and that they had the right, not only the right, but the obligation to teach it to their children. Bazelon said they had no such right because it violated the church and state. So he defended himself not on the grounds that they were wrong, or that they were incorrect in any way, or that they were unjustified in their decision, but that they could not cohere to the constitutional requirement of the separation of church and state. Would that be considered an overly rational decision, too narrow, by people who would like to take into account other kinds of considerations? Should the school district have been allowed any voice at all in this argument? That's a question I'm asking. I'm not making a statement. I'm asking this as a question to this group, which I think is more qualified than I am to think about it.
Well, I mean, it's a question that I mean, you're right. I mean, I think that we should approach that question with caution, because I imagine that most people in this room, or at least most people in the panels making a more modest claim, would have political priors that would line up with the result in that case, right? So the question is, regardless of whose ox is getting gored, do we actually have a broader view on this? My first temptation on that question is to, since it's such a Sarah Palin issue, to pull a Sarah Palin and say, I'm not going to answer the question, but speak directly to the American people. But I'll actually try and answer it. I mean, I think that my initial instinct there is to say, I mean, the Establishment Clause is pretty clear in saying that, I mean, our country is founded by people who are fleeing religious persecution. They're extremely mindful of the fact that religion could be used in extremely detrimental ways in public life. So at least with respect to the federal government, they had a belief that, one person's religion should not be another person's government, right? So that's, a clear historical and originalist notion, which even the people on the far right of the court should be able to assimilate, right? The comeback that they would have is to say that that applied to federal government, right? Because the First Amendment says Congress shall make no law rather than no state shall. So the question is, given that at the founding so many states had established religions, whether or not that aegis is broad enough to cover this particular instance, even though there's intervening doctrine that incorporates the Establishment Clause against the states, right? So that would be like the lawyer's analysis of it. But as a matter of Supreme Court precedence, it's well settled that the Establishment Clause runs against the states. So you can say that that's right or wrong, or you could agree or disagree with that, but that's actually the state of precedent, Now, getting away from a much more narrow sort of lawyerly discussion of it to the broader question that you were inviting me out to, which is the question of do I think this is rational or not, I would go back to what I was saying earlier to Anne, which is to say that the best response that I can give is to say, let's remember that the Establishment Clause, the separation of church and state, not only is there to protect the state, it's also there to protect the church, right? So I do think that it's really important to keep the government out of, or the law out of, devotional spaces in our life, whether that be, the literary, whether that be the psychoanalytic, whether that be the church, right? So oftentimes people don't see that this is a double-edged sword. People who want to cram all of their religious views into governmental spaces or public spaces don't understand that to the extent that they want that merger, that is going to often cut against them, because that's going to permit government to regulate their message and to change their message in a way that it couldn't if the wall between church and state were kept high.
Well, I guess what I'm trying to get to is the point that if these other considerations, these psychological dimensions, are allowed to intervene in these things, does that become a valid way to attack Bazelon's basic decision to confine himself to the scientific information that was available and to identify the other as a purely religious?
Right. Well, in this case, I mean, Bazelon, and as you've described the case to me, I don't know, but as you've described it, Bazelon gets a bye, right? Because the set of beliefs that he would denominate irrational also happens to be, in that case, religious, right? So it would be different if they were irrational but literary or irrational but psychoanalytic, and the school board were trying to say, well, we believe not from any religious perspective, but from a psychoanalytic or a literary perspective that creationism should be taught alongside evolution or what have you, or some more plausible cognitive value.
Or some other doctrine. That's
right. But I mean, I want to get on to other panelists and other questions. But I would really emphasize here that what I'm saying is that regardless of where the doctrine is, there is a real policy-based value in keeping the state from entering our devotional lives. Some of us put that in religion. I happen not to be one of those people. I put it in literature. I think it's no accident that literature skyrockets in England and starts getting taught at Oxbridge exactly at the moment, this is Terry Eagleton, exactly at the moment when religion is declining in that country. So I do think that there are substitutes for each other. We all have devotional spaces in our life that are better off, that irrational devotional spaces in our life that are better off because the state is not allowed to intrude there.
Thank you.
I just want to mention that there is a psychology to that case, which is the psychology of child development. And one of the things going on in those school cases is children are very impressionable, and there has to be a kind of monitoring. They are the sphere of irrationality in many ways in the law. So that's just a footnote to that.
Quickly to that, because I think it's a wonderful question, and it's a wonderful case that really, here's another domain that I think illustrates the ongoing vitality, for good or for bad, probably for good and for bad, of this distinction that's drawn, because Bazelon's opinion is a perfect example of sort of the legacy of really an Enlightenment rationalism, from the standpoint of which religious faith is seen in terms that are identical to the terms in which the Enlightenment rationalist or the Kantian rationalist looks at love or the emotions, right? Faith, like love, is blind. Faith, like love, is, if not downright irrational, it obeys a different logic. And that needn't necessarily imply a pejorative. We might have a kind of separate but equal and say, well, we're not saying there's anything wrong with faith or love. It just doesn't belong here in the public domain. But it's very much saying the public domain, if that's the space of reason, of public reason, of objectivity and neutrality. And while that's very attractive for all kinds of reasons for those of us who are worried about the harm to the state and society of religious capture of the state, or the harm to religion when the state is too involved, for one thing you can say for sure is it's experienced by proponents of the program that's being challenged as derisive. And it fuels that kind of rationalist reasoning has played a critical role in fueling the conservative backlash of the religious right, which will have enormous consequences for judicial appointments depending upon who's elected. Clarence Thomas has already expressed his sympathy for the position that we should reverse the decades-old jurisprudence that says the Establishment Clause applies to the state. He certainly seems to be ready
to the several states.
Right. So it only applies to the federal government. Right. It doesn't apply to the states, and it's quite possible that one of the products of that conservative backlash that I think is fueled by the perception of insult inherent in this kind of rationalist discourse, depends on the results of the election. But if it goes one way, then we might very well see a radical disestablishment of the Establishment Clause and other aspects of the Constitution.
Hi.
But if the election goes the other way.
My name is Edie Selman, and first I'd like to say I wish that Professor Yoshino was at our Shakespeare lecture. It would have been pretty snappy and a marvelous broad tapestry. You know, we had a Shakespeare lecture here 2 meetings ago. I think, what is it, stream? He can see it on the...
Yeah, it's on the past programming. You can go.
I think you'd enjoy that.
Thank you.
We had some really wonderful people here. But as a literary agent, I get material referred to me through editors and professors and so on who are in different disciplines. A long time ago, I represented a book by Cynthia Gillespie called Justifiable Homicide, Women's Self-Defense and the Law. It's still in print, and it was way before the O.J. case, and it was when Lenore, what's her name, Walker was an expert witness and so on. I've been watching that literature. I'm really more concerned about children right now, and married and Ailson, the Children Defense Fund and all. We don't have enough in that area at the moment. But the reason I'm up here is that we're talking about literature and the law, and I've represented lawyers who've been prosecuting attorneys and defense attorneys and write fiction. I also have represented people who do memoirs. So the words I want to throw out that I didn't hear today were two. One is perception, and the other is motive. I enjoyed hearing Carol say something about rational. The logic of psychology, that was an important thing for me to hear, as to the logic of the law. I also got a little chill from Mr. Bernstein, who said something about the jury. Is that your name?
Herbst.
Oh, Herbst, I'm sorry.
That's all right.
Okay. About the jury being diluted down a bit. And I think that when I go into a bank and someone says, oh, and sign this. Well, unfortunately, I'm an agent, so I read, and it says, and you waive your right to have to a jury. Why should I waive my right ever to have a jury? I said, I'm not signing this. They said, why not? I said, well, I just read it. I don't agree with it. That's one place. 3 or 4, 5, 6 other places I've seen where you waive your right to it. You go into your doctor's office. They want permission slips. There are all kinds of things about juries. And the Miranda rights, thank you very much for saying the most important thing is that what you say, anything you say will be used against you. That didn't come up, I think that's what, 35 years old, the Miranda rights? It's not that old. So, 2 things I'm asking. One is perception, okay? We know that if we tell someone a story about something that happened, and we want them, we take it away, we give them 3 minutes, and we want them to tell us, what did you see, what did you hear? You're going to have 4 different versions of what it was that you saw. So the truth and perception and guilt, when you say the person had some subliminal guilt or whatever and was provoked to do this crime, if the guilt is not removed and he serves the time for the crime, what happens with that guilt? Does he go out and do it again? We've seen, recidivism and all kinds of other things. So my 2 questions are, one, the word perception and the word motive in terms of behavior or cognition. I'm a little bit confused. It seemed to be sequestered into the logic of legislation and the openness of Shakespeare and Othello and which way we're going. So if you can give me a little hint on that, I'd be thankful.
Someone want to give it a shot?
I can go ahead, Dan.
I was going to take the Sarah Palin route, actually, and answer a different question. But go ahead. So go ahead. No. I guess this actually, it does go to, I think, the question of perception, perhaps, which is, and you bring up the jury trial, too. I think that what Kenji brought up at the beginning, so this is now circling around, this notion of coercion versus fancy, that, the law, we just can't get away from it, right? Robert Cover told us about it a long time ago, and it is, at the end of the day, there's going to be a judgment. And it's an empowering experience and a fulfilling one and dignity enhancing if the jury come back and says, your rights were violated. But when they come back and say, it never happened, or when the criminal justice system comes in and tells the rape victim, you weren't raped, after they've gone into court and voiced their experience, it's a very, it's a powerfully annihilating kind of feeling that an individual can have. So it's something I know Kenji's been reminding us of this, but it's something that we need to keep in mind as we think about sort of the effect of the law on individuals.
Can I'll take a stab at that too. Which is to say, Where did you go?
All the way around.
Oh, there you are. I mean, I think with respect to perception and motive, if I'm understanding your question correctly, I mean, one of the kind of the gestalt of your question was that the law tended to be closed and then literature tended to be open, because you talked about how closed legislation was and how open Othello was. I want to acknowledge that as a convention of wisdom. I think it's often said that the law closes the things that once were open, and literature opens the things that once were closed. So that's the convention of wisdom. I want to resist that, because I want to say, let's take Othello. Like, Othello is about both perception and motive, right? But we can see many cognates of Othello in the modern day. So the OJ trial was mentioned earlier. I'm actually, in my Othello chapter, trying to read Desdemona's handkerchief and Othello against a bloody glove in the O.J. Simpson trial, because I think in both instances what we have there is a piece of ocular proof or hard evidence that becomes the entire center of the trial, so that the ineffable metaphysical question of guilt or innocence gets projected onto this physical artifact. And the question is, did she or did she not give the handkerchief to Cassio? And the question is, does a bloody glove fit or does it not fit, right? And so I think that that's perception for sure, and it's perception that actually feeds into motive, right? But I think that the two scenarios actually have much more in common than they have, not in common, in the sense that in both instances what we have is that we are really, really sorry fact finders. We think we're really good. I mean, it goes back to what you were saying. We think we're very, the thing I would add to 4 different people are going to see 4 different things is to say that each one of those 4 people is overconfident that they've seen reality, right? And so I think that when we look at the bloody glove or when we look at the handkerchief, we are completely distracted from the things that really should be steadily visible. In Othello's case, he should be asking other people whether or not, Cassio has been, sleeping with Desdemona. He should directly ask Desdemona herself whether or not she's been unfaithful to him. In the O.J. Simpson case, there's this whole other set of hard evidence, and even restricting yourselves to hard evidence. There are blood spots in the car. There's things in the underbrush. There's things that are heard outside of Cato Killen's, things. So there's kind of catalog and fugue of physical evidence, but instead everything gets taken over by the glove with the, if it doesn't fit, you must acquit jingle that Johnny Cochran so artfully introduces, right? So in trying to determine, what the truth of the matter is, I think that the very similar questions of perception arise in both contexts. So I'm resisting the idea that, literature is open-ended and more flexible and more rich in its associations, whereas law is not. I think the law tries to present itself in that way, but in many instances it's not.
Look at Stolzenberg. Stolzenberg is a good kind of exception in a certain way, because here we have a full exposition of a person, the guilt, and yet the humanization of the predicament, and yet he's guilty.
Right. It's interesting.
This last question.
Last question.
My name's Jean Golden. I want to thank you for this really fascinating discussion. I'm more confused than ever.
That's what being a lawyer is.
But I'm just thinking, I was in court recently because we have a community issue, and we're sitting in the court, and right up behind the judge's desk, what does it say? In God we trust.
Look at your money, too.
Yes. So so there is some. Just as you've been discussing here, there is this confusion about what are we dealing with, what parameters are we dealing with. The other thing I want to mention is I've had to give a disposition at one point. This was when I was working as a social worker for children in a school system, and my understanding was I tell the truth, whatever. As meaning to me, that means being transparent, not holding anything back. That's my perception of what it means to tell the truth. Well, I was doing that. The lawyer got angry at me. Why? Because I told more than he wanted me to tell, which would mean that the other side would get certain evidence that he didn't want them to get. Well, I don't. To me, I want the truth. That's what I'm looking for. So, okay.
Thank you.
Wants to win.
Yeah.
Yeah. Okay.
Okay.
Thanks a lot.
Thank you.
Further information information about our programs and a complete archive of past Philip Tatey's events is available at philiptatey.org.